All right, we'll call the non-civil Judiciary Committee to order. We're going to start with House Bill number 896. That's okay, 898. All right, we'll start with 898, and that's LC 293926. Okay, Representative Collins.
Thank you, Mr. Chairman. This bill came to me. I got a couple of letters from attorneys, not only in my area but other areas. As you currently know, on the second or subsequent time under DUI, you have to put the person who's called has to post. They're paid to have their picture and their information put in the local paper. What I had was some lawyers and some others from across state we had females who were getting letters from the jail, and one of them in particular up in Hall County, basically the inmate wrote her a letter and said, "Hey, you look pretty good. I'll see you when I get out." All we're going to do with this, we're not changing any photo requirement, anything else. We're just taking the personal address out. They still are going to be in the paper. They're still going to have everything known. We're just taking where they can't have a personal address posted publicly. To me, it's just an information issue here and also a safety issue. So that's all this bill does. Okay.
We have Representative Levitas.
I'd like to be recognized for motion at the appropriate time.
Okay. Well, are there any questions from anyone? Okay, I don't see any questions. Is there anyone in the audience that would like to speak on this bill? Nope. Okay, Representative Levitas.
Mr. Chairman, I move to pass House Bill 898, LC 293926.
Okay, we have a motion to pass and a second. Representative Everson. I'm sure it did.
No, I'm good.
Okay. All right. Are there any amendments? No amendments. All right. We'll call the question. All those in favor of passage of House Bill 898, LC 293926, signify by saying aye.
Aye.
All those opposed, no. Okay. Bill passes.
Thank you.
All right.
Thank you, committee.
We'll go on to House Bill 896.
Yes. I believe this one will be about the same as the last one. This bill is a procedural issue dealing with a speedy trial demand, but mainly it deals with a very specific group of people. And this came, from a actual issue up in my circuit where we had one of the 48th who was deployed, and he was an officer, and he was called to, he was a part of this case. They filed a speedy trial demand, and because of the way our code section was worded, they had to go through the Section 301, Title V of the United States Code, which actually required them to make contact with the family, the commanding officer overseas. It just became, and as one who is deployed, knowing if you get calls back home and your commanding officer gets calls from back home, you're the one that's going to end up in trouble. All this says is something's already currently in code where they can get this continuance. All we're doing is taking out the language of having to go through this process, except this witness has been activated to duty outside the continental United States. And the way they show that is it's a military form called a CED order, which can only be cut under Title 10, which actually puts them overseas. And it's something that can easily be shown, and if that's shown, then that's all we're doing. This could be done already. We're just making the process just a little simpler for our folks overseas, because when they get contacted overseas on issues like this, it is a nightmare to try and work. And this one case just took a long time. So that's all we're doing here. We're not adding any rights or anything else. We're just making it a little bit simpler to show that this person is actually deployed in Afghanistan, and by the way, can't make court the next morning.
Okay.
That's all it says.
We'll recognize Representative Knox.
I'll waive. Thank you.
Okay. Representative Levitas.
Two quick questions. One, on line 17, that wouldn't cover somebody located outside the territorial limits of the state?
Not really, as long as you had the number 3 there, and that was what we were running into. We had a judge actually who looked at this and said, well, they're military, so let's follow the military this side, and it became an issue. I think this just clears it up, and that just simply makes it clear.
And then the only other question, what if somebody is located in Seattle, Washington, within the territorial? Why wouldn't we say if they're just on active duty located outside the state?
And that's something we looked at. The only issue there is typically depending on the mission sensitive, which then you could actually use the territorial limits. There's other issues you could use. All we're saying here is that inside the U.S. it's easier to contact that person, and there's not that framework of being in a war zone. that you could actually work with the person. The communication is much easier, and that's the only reason we said we wanted to say outside when you're actually in the war zone where places are hostile. We don't want you to have to deal with this in a sense that could be dealt with simply a piece of paper.
And I agree with that. I guess what I'm wondering is if we just struck that third sub-paragraph or whatever it is, Ms. Counsel, it seems to me that if I'm a court looking at this, I would say, well, obviously the legislature intended to apply a lesser standard to the military because we've already got ordinary folks are covered if they're outside the territorial limits, but with the military, even if they're outside the state, we're saying they're still subject to the court because they've said that they have to be overseas. And I'm just wondering, could we reach the objective you're trying to reach by just striking number 3 and having 1 and 2, and if they're outside the state, they're outside the state?
I mean, it's something that could be done. I think the biggest part here, we just were addressing the military part in the sense, and if we could address it that way, I knew there was an easier way to do it, and that was the CED order. So if that's the will of the committee, I've got no problem with that. I think it does still. One of the things in dealing with continuances and stuff like this, I guess I want to make sure, though I understand your point, I want to make sure the military is a separate sort of entity here, because I don't want anybody gaming the system or attempting, or it even be the appearance of gaming the system that I'm outside this limits, although this is currently in there.
Right. Yeah, I do, and I guess I'd leave it up to the committee. I mean, what I have in mind is maybe just adding to line 17 after the word state, including but not limited to a witness who has been activated to duty outside of the continental United States.
I think if you include that language, that'll cover. I mean, I think it covers it both ways. It's a stylistic issue, whichever way you would like.
Okay.
Or unless council has something else on that.
Well, these are 1 plus 2 plus 3 plus 4 because they're
Yeah.
ands. So,
Okay.
You're right, Representative Levitas, that this is an extra layer if you wanted with respect to people who are serving in the military.
Is this, and Madam Counsel, maybe this is the question, is this particular subsection C related, is the intent to treat just military folks? In other words, if we strike that out, are we then creating problems by saying the witness is outside the state? In other words, was this particular subsection drafted just to address, since you're saying it's an and as opposed to, it may have been that the intent was to make this apply only to the military, in which case I think we have to leave it the way Representative Collins has it.
It is. That is, and that was one of the things we went into because this applies to military and not the others.
Okay.
Issues. That's why I wanted to leave it
Okay.
as it was.
Okay. Thank you.
Do you?
In that case, I'd like to be recognized at the appropriate time for motion.
Okay. All right. Will Representative Knox.
I'll waive. My question was answered.
Okay.
Thank you, Mr. Chairman.
All right. Representative Lunsford.
Thank you, Mr. Chairman. I just have a question for
Okay.
you. The preamble of the bill says that we're involving a witness who is on active duty. Of course, we all know the preamble is not law.
Right.
It's just a description. Is this the correct terminology when it says has been activated to duty? Is there a definition that means military?
Yes. That is a definition in the context of this bill that once the CED, and I'll explain it, the CED order that I spoke of that they can show that they're active actually is the Title 10 order. And there's several versions of Title 10 order, but Title 10 order that takes you off of, if you are a guard or a reservist, that takes you to active status.
No, I understand that because I was an Army brat.
Right.
But that part, but I'm just curious, have we fully covered it? Because it says witness has been activated to duty outside the continental United States. The terminology activated to duty, does that automatically imply military, Jill? It does, or?
We ran this up the flagpole with military folks.
Yeah.
And we took maybe
Right,
we
and
had
they were comfortable with this and saying that this is what they actually came to court to testify on and saying, hey, we'll show you the orders. This person. I understand what you're saying. It from the context of this bill, yes, it implies military. And
But
really, I'm trying to think of another scenario in your question that would provide somebody as being activated.
Well, I mean, I guess.
What if you were a private contractor with?
The guard, not the regular army, though. I mean, that may be the distinction.
Right. And I think for the guard and reserves, you have to transition titles.
Those
And I think
activated.
right.
But when you join and you're not as a you're activated when you.
Yeah, you're active duty in general. Yeah.
Don't you think maybe we could clarify it by saying activated to military duty?
That's fine. Yeah, and that'll clear it up.
Yes, sir. I'm fine
No,
with
I'm
the bill. I
good.
just wanted it to be clear
No problem.
so that we didn't have a private contractor that uses the terminology, we activate our people to duty in some other country. You got a guy standing trial, he asked his boss, said, activate me to Mexico.
Right.
He just got out of trial.
Right. Well, I think military will clarify it.
Yes, sir.
I think we
Think
should.
that-
Thank you.
Point is well taken.
And I would take that as a offer that as a friendly amendment. I would say.
Okay. Representative Thompson.
Thank you, Mr. Chairman. I guess I'm still a little confused. These all appear to be ands, with number 2 saying outside the territorial limits of the state, but number 3 being outside the continental United States. Is this only intended for people who are outside the continental United States? Because what if we got somebody on active duty, but they're in California or another state, and we're trying to get them back for a trial? Does it not still apply to them? And aren't we, by that, restricting it so that it doesn't apply to them?
I think in the issue that where this has become an issue, and again, it's been brought to my attention, and I've not, and have taken some questions and also run it with military. There doesn't seem to be an issue with the Continental in this sense. There seems to be more of the issue that we've seen because of, and really where it comes from is the massive use of our reserve and guard forces in right now, which I think make up in Afghanistan and Iraq, currently make up probably the 3rd to 45% of total force involvement. That's caused this issue to become a little more prevalent, especially with the overseas. And it was just a simple area where the person, from a perspective could use, and they just wanted to clarify that because we ended up, in this case in particular that we're talking about, they were ending up having to bring JAG officers from Fort Gillem up to try and testify to say, Your Honor, this person is overseas. So that's where they've seen it the most. I think it still applies to, as it always has, in that sense, to people who are inside or outside the territorial states. I think what we're doing here is simply making 3 a simpler process, Representative Thompson. I don't think we're changing anything that's not currently been in law and how you define it or who's affected by it. All we're simply doing here is taking the 3rd step, it's line 3, and saying by proof of a CED order, which can easily be produced for someone who is actively outside the continental U.S. That's what we need to do, because in the cases and in the conversations that I had, that was a concern. They could not just simply produce the order. They were having to go through this process of commanders and other things, which was an onerous process and not that it couldn't be done, but you're putting a position where this commander's having to now think about a troop and getting their letters and everything back. So that's where it really came from.
And I have no problem with the bill, and I certainly understand that. I just don't know what Section 301, Title V of the I don't know who that applies to. And what I'm concerned about is if you got somebody in California who you can't get here for a trial, that you can't get it continued, or it's not going to toll the speedy trial, and that we may be causing a problem we don't intend to cause.
Mr. Travis, can you tell us something about Section 301 of Title V, USA?
It says barely anything, and it really, I don't even know why that reference was in there when I looked at it. I'm not refreshing my memory, but I remember when we were drafting this bill, it was like, if you ever looked at it, it was like, this makes no sense.
Right. And that was part of the issue, and you were having to go through this whole contorted thing to get to this part. And again, in the sense, and I actually had a conversation with the folks yesterday with trial lawyers when we were talking about this issue. It really, all we're simply sitting in here was a clarification of this procedure. So in essence, it's something that's been in our code for a long time as far as continuances, but now we're just setting it in here for procedure.
I think that the point that Representative Thompson was making, which I think is a good point, is that if this was originally intended to benefit not only those that are deployed outside of the continental United States, but those who are on duty inside of the continental United States but are out of state, then we may be cutting out some of those protections that would otherwise be provided.
And Mr. Chairman, it just seems we may be being inconsistent when 2 says outside the territorial limits of the state, but then we add 3 to outside the continental United States. If we said the territorial limits of the state there, it would seem to be consistent.
That does seem a little strange.
But I just don't want to cut out that you can't get somebody here in 2 days from California because of their military duty, and we can't get a continuance because of that.
Okay.
Well, here,
While
Ms. Travis looks that up, let's go to Representative Knox.
I think what the striking is simply to remove the reference to the federal code,
Right.
which is where the process is located. We don't have that process
We
in
do not.
state law.
No.
It's only that you have to do this because the person is subject to the military authority of the United States government, not
Exactly.
to the state. So that's why that's the first thing we're trying to do. The second thing is that you could have a witness, however, who could be activated, as we've described it, to duty outside the continental United States and be located in the state and actually be available. They just haven't left yet, but they're
Right.
within the state jurisdiction of the Superior
Exactly.
Court, and usually that's who the Superior Court in that state. So they could be subject. And so that's why these are all ands.
Yeah, the ands.
Yeah.
And it's a process, and that was simply, we're not trying to change the process. It's already in place. We're just simply making that available to them to clarify. Instead of Georgia, as we in this committee have done many times, instead of having to go to the federal, we're doing it ourselves, and we're saying here's how we do it here, instead of being referenced to a vague federal code. I appreciate that.
And this doesn't apply to witnesses in general. It just applies to witnesses in connection with speedy trial demands.
Exactly, and again, a very limited area here.
Ms. Travis. Okay.
Oh, it's the computer's fault again.
And there goes the object across the table. Even better reason to strike him, Mr. Chairman.
Right.
We don't care what they say anyhow, do we?
I'd rather have states' rights on this one. Let's just go back to that.
Do you?
We're done.
Do you?
To assure the committee's response, Ledge Counsel Jill and I did discuss this. We did look up the code, and as one of the part, and it was, like I said, it was this vague amorphous standard that really led us to have to follow federal mandate on this to start. In this particular case, they were having to get the wife to come in. They were calling the commander. The commander was calling back from overseas. And we're just saying, no, we're not going to reference Georgia. We're not going to reference to a U.S. code. We're going to say, here's how we do it here. Here's how we're going to handle it. Because we do have a large military population, especially reservists in Western Florida. So that's all we're doing.
I guess the question is, though, let me ask you this: is your intention that a person who is been activated to duty but is still within the continental United States would be afforded the protections under this statute or not?
Yes, they will be afforded. It's my understanding they can't, and again, from what we have already in place, it does not affect their standing. Again, this is also
You're saying because they have been given an order
right.
to go to active duty, even though they're still within the confines of the United States.
We have, and here's where, let me again explain maybe from the military perspective here. I can be activated for a number of reasons on active duty orders and still be within the United States, but not be under what I would call a wartime condition. I could be in Seattle, but I would be under almost, and I don't put this lightly, but a 9-to-5 job. Okay? I could be working and could arrange for time off and time to which I could basically, I could either get the continuance if need be due to mission constraints, or, I could maybe even actually work with the court on this. So we're leaving it in place to where I believe it's functional for the military member and the courts as well. So I do not see a restricting or really enlarging either of rights here. I simply just see this as a clarifying language to a current statute.
Well, I just wonder. I agree, and I understand the intent. I just wonder if ultimately if we're clarifying or if we're muddying the water, because I wonder if we could sort of wordsmith this a little bit to perhaps make it a little bit clearer.
Would it? And just as for working with a committee, which I've always wanted to continually do.
We appreciate that.
It is. I have to say this is my home. It has been since I've been in the legislature, and I love this place here. It's the twitch that bothers me. The head of an executive department or military department, this is 301, may prescribe regulations for the government department, the conduct of its employees, the distribution and performance of its business, and the custody, use, and preservation of its records, papers, and property. The section does not authorize any withholding of information from the public or limiting the availability of records to the public.
That doesn't really help a lot, does it?
Could I get an amen now and pass the plate and say that we just don't need to follow that anymore?
Well, we still go back.
Would it be best as this? I'm going to offer a possible solution here in taking into account what if we took line 2 and I think was mentioned, I'm not sure and maybe it was Representative Liz or Lunsford, and take line 2, take it at the semicolon, and just move the language up to 2 and strike the rest of 3. Or what do you think, Jill? Or I'm concerned we're fixing a problem that doesn't exist. And Mr. Chairman, I'm almost.
Well, I don't know that's necessarily the solution to it. As I originally heard what Representative Levita said, but then the more we've discussed it, I'm thinking that maybe we need to leave that in there, but we need to wordsmith it so that maybe it makes clear that that they don't actually have to be outside of the continental United States. Do you have a suggestion, Ms. Travis? Because it's number 2.
Number 2 takes care of outside the state. And they got to be unavailable.
Well, let's hold on, Representative Knox.
But here's the problem I have about it. If they're in the state of Georgia, and they're available, whether or not they have been activated for military duty, they should and ought to come, and the court should be able to require them to come. And I think it might be a violation of the jurisdiction of a court to prohibit them from going there.
If he's not located,
right.
If he's not located
I agree.
outside, if he's not located outside the state, then it really puts a whole different issue on it. So.
But that's why I'm saying. But all of these have to be.
And this
in
is
there.
also, remember, is also under discretion of the judicial discretion too, as far as granting the continuance.
I think taking out the procedural language that we took out doesn't change the effect of this code section at all. It's just a different method of providing the information. It's just instead of having to go and prove that you've gone through this little process with the military, that you can just say here's his copy of his orders. He's on duty and he doesn't live in this state. He's somewhere else stationed in this.
Right.
Okay, let's go to Representative Levitas.
Mine was exactly what.
Okay, Representative Thompson.
It's been taken care of by what we said earlier.
Okay, Representative Benfield.
Thank you, Representative Collins. I think you said judicial discretion. Is that because I see on line 13 it says the short shall grant?
Well, if this is followed, and that's what we're basically in this, and that was a and for those of us who understand, that was a mistake. What we're doing here is laying it in there so the judge can have a clear. This was the problem my judge and the district had when they looked at this section. It was, what do we have to go? What hoops do we have to go through here? Mm-hmm. And so that's all we did is took out this procedural issue, which to a code section that is untenable, and just simply said, here's how you provide it. So that's all we said. So I mean, I understand your ears perked up on that part, which you should have, but it was not meant to say anything except now they have something to follow. The judicial, when they look at this, they say, we presented the order, we follow it, here's what we do.
And when these criteria are in existence, the court must grant the continuance.
Yes.
Okay. Can I ask a follow-up question? My concern with allowing other states duty in other states is if the material witness is in Florida and is on active duty in Florida for a year, and you've got someone who's demanded a speedy trial, then they're sitting in jail for a year. And the person's maybe not that far away. Like maybe they're stationed in North Florida, and we're talking about a courtroom in South Georgia.
I do not disagree with your concern, but here's the thing, and it's just almost like some of this other bill. This bill does not change anything that currently exists. Nothing.
I just had trouble understanding what currently exists when
This
you
is
read it.
What you say here, except for what is Strickland, is what currently exists. So however it's been, in how it's played out in court cases all over the state for however many years, it will still stay the same, except for the procedural language of line 3, or of section 3, 18 through 21, where we simply say, instead of interpreting it by this U.S. code, we're saying all you need to do is present the active duty orders. Nothing else changes.
Okay, thank you.
Mr. Travis, can I run some language by you? Suppose that you changed, beginning line 20, witness has received orders to deploy for military duty outside of the continental United States.
Well, the problem with that is if you I can receive the orders today that I need to deploy in March to Afghanistan. So just my receipt of the orders and the next week.
But provided that they're outside of the, going back to number 2, they're outside of the territorial limits of the state. You see? I mean, I think that was the intent. Okay. Representative Levitas.
Two things. One, I don't think there's quite no discretion for the judge here. And if you look at actually number 4, I think it addresses the problem. The witness will not be available within the time limits prescribed by the code section 17.7. In other words, if they're in North Florida and the judge determines that they're available and they could get here, he or she could say this doesn't apply. And this does address that situation where somebody is in the continental U.S., they're on military duty. If they're in Seattle and there's no way to get them there within time, that's one thing. But if there is a way to make them available, then I think the court has discretion to say that the speedy trial demand is valid.
So you think the current
language
as it appears in the bill is adequate?
Is adequate to address Ms. Benfield's concerns.
Mr. Chairman, now let me just also say, my concern here is that if we continue to tweak the other parts of this bill, we may end up doing exactly what we're intending not to do. We may end up actually restricting or causing more problems in a bill when we're simply just taking out some extraneous language and making comments. That's my concern at this point. Which
we can't hardly believe that.
We're family. We can talk about this, but that's
Representative Knox.
I'll waive.
Okay. Well, let's. Okay. Well, let's go ahead. We'll take the motion then. Representative Levitas.
Mr. Chairman, I move to pass LC 293959.
We haven't. Do we have a second? Okay, we have a motion and a second. Are there any amendments to the motion?
I would, and this is going back to the adding military duty.
Yes.
That one word which I offer is a friendly, if somebody would offer.
Right. Okay. Any amendments?
Yeah. I offer it as a friendly. I offer it as my own amendment. Is to add on line 21 military duty after 2. I've been sitting on this side of the table too long this week. This is. Bill, is this friendly?
Check to be sure he's got a friend on here.
At this point, we're all checking. We're pulsing. Line 21, just add between 2 and duty military.
Okay. All right. Is there any discussion of the amendment? All right. We'll call for a vote on the amendment. All those in favor of the amendment? Well, right. Well, okay. Is there any objection to the amendment? No objection to the amendment. The amendment is adopted. All right. Is there any further amendment to be offered? No. Any discussion? Any further discussion on the bill?
Yeah, I'm sorry. Did we address the issue of the striking outside the continental United States? If we haven't, I would offer that as an amendment. Strike on line 21 from outside through states.
Okay. So beginning line 21, starting with outside and strike through the word states. Is that correct?
Right.
Okay.
No.
Yeah, I do. The reason for that is that you've got in number 2 that they're located outside the territorial limits of the United States, outside of the state. And then, as I said, I think number 4 gives the discretion of the judge if they think something is some funny business going on, then the judge would still have the discretion to say, I think this person's available within the time limits, and therefore I'm going to let the speedy trial demand run.
Okay. Hold on just a moment. Representative Knox.
Are you trying to make the distinction between the continental United States and the United States? Because we have states that are not within the continental United States, like Hawaii, Alaska.
That's actually outside the continental United States. But I'm happy to do it. The whole point of this is I don't think it matters where the person's stationed. It matters whether or not they are truly available. If they're in the military and they're truly not available, that's one thing. But to address Ms. Benfield's concern, if you've got somebody who's stationed in Birmingham and they can get here in 2 hours, I think the judge ought to have the ability to say, hey, they could be here. We've given the military 6 months and they still haven't made us available. But I think we're making a mistake to limit it to the outside of the continental United States, because there are circumstances where somebody could be stationed and they cannot get back within the time, especially having been in prosecution, and the vice chairman knows this. You often get these speedy trial demands filed right at the end of a term with the specific purpose that they won't have an opportunity to get the folks back here in time. And I'm not in the military, but my understanding is that it can sometimes take a little while to get these things moving forward, and I just don't think we need to tie the hands of folks serving the country or the prosecution or the defense in the way that we would if we limited it to outside the continental United States.
Okay. All right. Representative Thompson, you waive? Okay. Any further discussion on the amendment proposed by Representative Levitas? Representative Benfield?
If Representative Levitas' amendment passes, then it says witness has been activated to duty.
To military.
Military. Okay, okay, sorry. Just that much clearer. Thank you.
Yeah, we fought that one out, I think, before you got here.
Thank you.
Okay. All right. I would point out, I think that, Ms. Travis, correct me if I'm wrong, but I think that this code section is not a discretionary with the court. It's mandatory if the court makes those findings. 1 through 4, is that correct? It says the court shall grant the continuance. Okay. Representative Levitas.
Right. The discretion comes in line 4. The judge is the one that would have to determine whether or not the witness was available, and that's where the discretion comes in.
Well, factual.
Right. And if he or she determines that they are available, then the code section doesn't apply. If he finds that they are not available, then you're right, it's mandatory.
Right. Okay. All right. Representative Benfield.
One last point. Do we want to clarify U.S. military duty or just say military duty? It's material witness. They could be in the Argentinian army or wherever. What does the code say? The U.S. federal code.
We've already
that was
plowed
an
that
amorphous
ground.
little language over there that didn't work.
We do have citizens of other nations that serve in the United States forces too, by the way.
Oh yeah.
But I'm thinking, material witness could be from any country, and you just want to say military duty?
Representative Levitas.
I guess the question is, it almost doesn't matter. What if there is a witness who's in the Afghan military who is a material witness, whether they're Afghan, United States, if they're on military duty? I still think this code section should apply. Or if they're on duty with Mossad, as I might be at some point.
Okay. All right. Well, let's go ahead with Representative Levitas' proposed amendment striking outside of the continental United States. Is there any objection to the adoption of the Levitas amendment? No objection. The amendment is adopted. Okay. Any further amendments? Yes.
I'll do it. Ms. Travis came to me on line 17 and said strike the and put this, and this I'm assuming is a Scribner's issue. Would that be? It's this state and not the state. Sometimes we refer to ourselves in third person, but
changing
the state said
the state to this state.
Right, this state. Just
okay.
Transferred.
All right. Is there any objection to the adoption of the amendment changing the to this on line 17? Okay, no objection. The amendment is adopted. Any further amendments? Okay. All right. Well, now we're on the main question, passage of House Bill 896, and this will be by committee substitute. Is that? That's correct. Okay.
Yes.
All those in favor of the passage of House Bill 896 by committee substitute signify by saying aye.
Aye.
All those opposed, no. All right. Bill passes.
Thank you.
We
Committee,
will have,
Chairman.
the chairman indicates we will be meeting tomorrow at 1:30 p.m. in this room. So plan on it. 1:30 tomorrow in this room.
Okay.
And we are concluded. We're adjourned.
Thank you. Thank you, committee.